Joshua Arnone. Check proof of concept. Okay, I wrote, sir?
Uh-oh.
I changed that from noted to present, and I typed in P.
No, it's the letter above it that matters.
Okay,
yeah.
okay.
Just the letter. You've got present there twice. Make that a
Okay,
B.
so take this.
Here, let me do it. See, the thing is helping.
Okay.
There you got it.
Now we understand. It does work. Okay.
Just a little technical stuff. Hold on just a moment.
All right, we can do this now.
Okay, we're ready to go.
Benjamin Backrack.
Point of information,
Sir.
if nobody calls for a quorum, we still have to go through this process each time.
My understanding after a break you do.
I've been to 19 other conventions, we've never done this.
Lynn, do you know? That's my understanding. When you break officially and you come back, you have to do it again.
I recommend that Suzanne knows who's checked in here,
Uh-huh.
and she could just give us the number of delegates that are present at the convention. We look around the room and determine whether or not there's a quorum.
Okay.
If there's a quorum, we proceed.
Okay.
I think we got a quorum.
I'm fine with that. We'll make that the ruling. Thank you for your expert assistance. Okay, we're going to go forego that. Is there a quorum present? Does it appear to be a quorum
Yes,
present?
there's a quorum.
It sure does look like it to me. Thank you, sir.
Good, thank you.
I thought we had to do that every time.
Yes.
That helps.
Okay. That leads us to item 12, somewhat mislabeled consent agenda item. Dana, do you want the floor? I recognize you, Dana.
She needs a microphone.
I know, she needs a mic. All right, so if you look in your package, you should have an item that looks like this, which says motions from Rules Committee to amend the LPF Constitution and bylaws. The motions have a large number, but the last digit is a 1 or a 2 or a 3 or a 4. And she's motioning to put those all into a consent agenda, so that what that means is we will vote on them all at once, or that somebody could object. So we need a second on that motion. Oh, okay, it's been seconded.
Okay, who's making these motions, please?
Dana made the motion to put these in a consent agenda. It's been seconded.
Seconded by?
Lynn House?
Dana, would you like point of privilege on this?
I still need some clarification. You're talking about the constitutional items 1, 2, 3, and 4? And not at this time the bylaws or the one standing rule, is that correct? All right. Constitutional amendments 1, 2, 3, and 4.
Correct. Point of privilege on that? You have the floor. Well, do you want to discuss? We're in discussion. Do you want to lead? Okay. Omar, you're recognized. I'm sorry?
Now.
You object to one of those items?
I knew it was coming.
Okay. Number 4 is stricken from the consent agenda.
Number 4 is pulled.
There's no vote on that. It happens automatically. Any other objections? Any other discussion on that? Okay. No? Very well. Let's bring it to a vote. All in favor of accepting this consent agenda with items 1, 2, and 3 on it, say aye.
Aye.
All opposed? Motion carries. That saves some time.
That's why we do it.
Now we got 4. What's wrong with 4?
All right. We put those on the consent agenda. Now you want to? Okay. Now we shall vote on the actual consent agenda. Very well. We already took the objections to this. I'll just have another vote. That'll, all in favor of accepting this consent agenda, say aye.
Aye.
Okay.
All opposed? There we go, just in case we weren't sure. Now we got it. I thought we had it for sure.
Right.
Yes, motions 1, 2, and 3 are passed. Do you want the floor, Dana?
She needs a mic. She needs to come up here. She needs to come up here or get a mic. It's absolutely essential. Dana, please.
All in favor of
And-
Dana coming to the mic?
Yay.
And please again.
And watch out for this deadly thing.
And could you please again state what it is that you are doing, because I was not able to hear it up here.
Okay. We
So
are
start
on-
over.
Your name,
It is-
please.
My name is Dana Moxley Cummings, and I'm from Pasco County, Region 8. All right. This is Constitutional Amendment 4. It is the motion to amend the Constitution, Article 3, Section 7. It will strike the current Section 7 membership committee and replace with the following language. And as mentioned, there were a couple typos in here. I'm going to read it the way that it should be read, and maybe
Do your
the
thing.
secretary can change that in the motion. Section 7 will now read, if this shall pass, the membership committee shall be appointed by the chair and confirmed by the executive committee. It shall consist of at least 5 members of the LPF, with the majority not being members of the executive committee. The committee must include the LPF secretary, who maintains the membership records, with assistance and guidance from this committee. The principal duties of the membership committee shall be responsible for increasing the membership in the LPF and for increasing the LPF voter registration. The membership committee is also responsible for recruiting members both for the affiliate and for the LPF.
Do we have a second?
And Hal seconded it.
Okay, then Hal second. Point of privilege?
It's open for discussion.
I did not,
Then Hal
Omar, you recognized? You want to move the motion, the membership committee shall be appointed by the chair at the annual convention? Is there a second to that? I hear no second. George? Yeah, go ahead, sorry.
I see no such rule. I'd rather have it all eliminated
Okay.
than added.
Was there a second? Okay. Personally, Omar, I'm concerned with the wording. Why would you confirm it by the executive committee after that? I mean, if it's appointed by the delegation, why would the executive committee then affirm it? Because that's how the wording reads as it is now. Because you didn't say strike, or if you did, I didn't hear it. Right, so it reads, "The membership committee shall be appointed by the chair at the annual convention or annual business meeting and confirmed by the executive committee." So that seems a bit strange to me. Could you read it to me then, how you want it written?
May I be recognized?
Please, you're recognized.
I don't know, I can't be 100% sure, but I don't think that the membership committee is one of the committees where your term expires once you're on that committee. So I think when you're on that committee until you put in your resignation.
For life.
Forever. So there are certain committees that do have timeframes, but I don't believe the membership committee is one of those.
You're recognized, Pete?
Yeah, point of information, would this mean that if you're like halfway between one convention and the other, if somebody in the membership committee drops out, it's just gonna stay open? Is that the idea? If I may direct it.
Yeah. Omar, would you like to respond to that?
Well, you said it's after, the wording is very specific, it has to be done at this convention every year. Suppose somebody in December, a group, let's say 3 or 4, decides in December for various reasons they have to drop out.
God forbid
It's
that
going to
happens.
stay open on the membership committee until the convention. Is that what you're trying to say? No. Then there should be something in here, go ahead and say this will be appointed at the annual convention and, you know, if somebody drops out, there still has to be one or two. Otherwise, the committee could conceivably also go to fund, it could not work.
All right, any other discussion? Sir, you're recognized, please stand. You want to make the appointment temporary pending the next?
Why do
It's-
that?
it's- I'm not supposed to discuss, so I'm going to shut up. Mr. Dick Creamer?
I'm just looking at Article 3, Section 3, where it already has the Communications Committee as one of the standing committees. And your actions on appointing members of the committee is already addressed in Section 3, Paragraph B. So we need to do it again.
It's already addressed, you're saying? Section 3, paragraph B? Okay, for those who didn't hear. Did you, sir?
I'd like to call a question.
Yes.
Call the question, okay?
Can we do a voice vote, or is that a roll call vote?
All in favor, oh, well, you call the question. Is there a second in discussion? Call the question. Okay. All in favor,
Okay,
in
so
discussion,
what-
say aye.
Aye.
All opposed? Okay, we'll go to the question. On this motion to amend, if you're in favor of amending, say aye. There was a few. If you oppose?
Nay.
Motion fails. All right, we're back to the main motion. Dana?
All right, back open for discussion on the main motion.
Any discussion on that? I should have done that. I'm sorry. I thought you wanted to discuss. Any other discussion on the main motion? Okay, we'll go ahead and go to a vote. All in favor of amending the Constitution here? Let me scratch that
This
out.
must pass by 2/3.
That's a good point. Say aye.
Aye.
All opposed? Motion passes.
That sounded like 2/3 to me.
All right, next we'll move on to Constitutional Amendment 5. Motion to amend Constitution, Article 6, Section 2. This is a motion to amend Article 6, Section 2 of the Constitution to delete the current wording and replace it as follows. Section 2, amendments to the Constitution may be made in one of the following ways. Amendments must be published on the official LPF webpage, and notice of that publication must be given to the Executive Committee, the county affiliates, and all members in good standing 30 days prior to the annual business meeting. Only amendments that are properly published and given proper notice will be heard at the annual meeting. This Constitution is amended by a vote of 2/3 of the membership at any regular or special meeting. B, upon establishment of affiliates in each county in Florida, a proposed amendment can be accepted by 3/4 vote of the Executive Committee and ratified by 3/4 of the county affiliates. Section B is already what's stated. What we are voting to amend would be the last.
Should be the underlined stuff.
The end of the last sentence of 2 and A.
Is there a second? All right.
Who seconded?
Felipe,
Thank you.
point of privilege?
Somebody else I'd like to speak on this one, because I was not in favor of this one in the Rules Committee, so I know somebody else that was in favor of
Does
this.
anybody want to discuss this item?
Okay, well then I'll speak out against it. As you see here, I mean, a lot of things are done last minute. We're all volunteers and we're doing the best we can to get it all taken care of. And I know there was an issue in the past with notice and what did notice actually mean. We discussed how sometimes notice for public hearings just means they just put it in a newspaper and nobody sees it. They just put a sign in the ground and then that counts as notice. And, you know, 30 days is a long time. We had to get in under the thing. I mean, a lot of things can change in 30 days. And I think that as, you know, as people that are going to come to the convention, if you're going to be delegates and you're going to be voting on these types of things, there's very many there's places you can go seek out the new language or ask your affiliate or come to somebody on the EC or your regional representative and ask them for the, you know, what the changes may be. So that's why I'm against this.
Lynn, you're recognized.
County, I'm going to speak in favor of passing this. The Constitution is very important to the structure of the organization. It should be difficult to change, and if it's going to change, you ought to know about it well in advance. Sometimes changes are so dramatic that you might want to make plans to come when you didn't think that it was otherwise important. This describes exactly how that the proposed changes will be announced. Last year we had problems with this, and this is an attempt to correct those problems and make it perfectly clear how the membership is notified of changes to the Constitution.
May I address also?
You have the floor.
We did have problems with this last year because one of the issues that occurred was that the state requires specifically in statute, I can't cite it to you off the top of my head, but the statutes say that we must publish 30 days in advance and it shall be on the website. This was not done last year and was part of the problem. So, and it was the key issue when notification was given in another manner. So we're trying to establish here exactly how it's done to provide guidance in the future so that all the conventions going forward, everyone will know to make sure it gets on the website and that it complies fully with the statutes, with the law, and it gives all of our members ample time to make plans to be here or to get others to, you know, hear their point of view who are attending. And it's just the best possible thing that you can do to make sure that we're in complete compliance.
May I be recognized?
Yes, Dana, you're recognized.
And with dealing with the law, whenever I had asked them about that in the past, I mean, as we know, the state can change their mind depending on who you talk to or what day of the week it is. But they said that it had to be published on the website, that we would be having a meeting and we would be discussing changes. We didn't need all the wording of everything that we were changing on there. That was why we were considered in compliance with the law in the past when we did that, because the state said that we were. Of course, we know that can change. The state can change their mind at any given hour.
Omar, do you want to address this? He asked the statute. She said earlier she couldn't quote it though.
I don't have it off the top of my head. I know we talked about this for half a day a year ago.
So go ahead.
Yes. So apparently, if this is passed, it means that all motions. There would be no more motions from the floor. I don't believe that there would be motions from the floor if this passes.
That's how it reads. Is there any other discussion on that? Pete, you're recognized.
Yeah, people in Local Luso. When I read this, the one question I had, the purposes sound fine. nothing designating here who actually does it. And remember, in this room, we know each other, we have some idea who does it. Of the remaining 22,000 or 25,000 now Libertarian authority, they're not gonna know. If they wanna do an amendment, it has to go to somebody who's specifically responsible for it, or it's gonna get lost. Nothing will happen. So I would like to suggest that the question of who does it has to be designated. It should be put in here. If you're gonna require it to publish, you know,
Are you making a motion to amend?
I guess I will.
Okay.
Then I have to come up with specific wording, don't I?
Yes,
Alright.
That
correct.
means somebody has to do it. Am I gonna go ahead and say the secretary ought to do it? I
Pete
have no
Bloom
idea
should
what
do
other
it.
duties are.
Pete Bloom should do it, yeah. Okay, so you're amending that to read, you motion to amend,
I guess,
Here's a thing to fill out if you would like to make your motion.
well, that's, he doesn't need that, he doesn't need
He
that.
doesn't need
No.
that?
for purposes of discussion, I'll go ahead and make the amendment that,
The motion?
must be
It's only on
published
this
by
one.
the secretary. That is only for discussion only. That'll get it open for whoever comes up with a better idea on how to.
Is there a second? Okay. Pete, as the motioner, point of privilege on that? Motion that you just made to amend? I think you already did your discussion, but I'm just giving you the option. Okay, sir, you're right next.
If we put this power in the secretary's hands,
You need to stand, sir.
and your name. The land for
Second.
One of
I propose that if we put publishing in the hands of the very small, one person, for example, that they have almost a veto power. And I also question, having the state laws restrict us as much as they do. I agree completely if you're saying that 30 days is awfully long.
Hang on a second. Did you, yeah, do you want to repeat that to them, facing them? There, yeah, you can stand right here and use the mic if you'd like.
I suggest if the publishing decision goes to just one secretary or one person, they essentially almost have a veto power. Not that you would, but, it's awfully easy for everybody to put something on a web page. That makes it more free. The second point was that 30 days is not a long, or is a long time, and I agree with what you said about that. I think a shorter term would be reasonable, half of that perhaps. But are we violating a state law, and why should we be restricted by state law like that? What can we do to change it?
Thank you. Did someone else want to be recognized? Hang on just a minute. Go ahead, Philip.
Well, instead of the secretary, this is rules committee change stuff. I think it should be the rules committee that publishing changes.
Okay.
So is he making a motion to amend a motion to amend?
That's as far as we can go, right?
Yeah, we have to first, this is on the table.
Yeah,
We have this.
Or is that a friendly amendment?
we're not doing friendly amendment.
I think a rules committee sounds great. Considering I haven't really thought about this, it's very good veto thing too.
Well, let me just
Okay,
say,
hold on.
the Rules Committee has no idea how to publish anything on any website, so
Yeah.
I don't know. That's why we have a Communications Committee and a secretary to do the
Well, yeah.
communication.
I think that's just for clarity's sake, the word published, I'm concerned is being misunderstood. That just means to make it available publicly. It's, I saw a lot of hands. Jean-Luc, you're next, Omar. Okay. Thank you for that, Jean-Luc. We actually have a motion to amend. The motion to amend, the man, Philip, said that this should be the Rules Committee, correct? They changed that from the Secretary to the Rules Committee, and that was seconded. Is that correct? Did somebody second that motion? It's seconded now. Okay, that is the motion on the floor. Does anybody want to just changing from the verbiage from Secretary to the Rules Committee? Omar, you're standing. Does that mean you want to address that? The first amendment was by Pete. He said to add the text to publish, and the new text was by the secretary. That was the first amendment. And then that is now being motioned to amend instead of saying secretary, rules committee. So it would read by the rules committee if this amendment to amend is passed. Oh yeah, it's gone there. Did that answer your question, sir? Is there any discussion on changing it to the rules committee? Lynn, you're next.
The rules committee is too vague. What does that mean when you say the rules committee or something like, the rules committee is gonna sit there and look at each other and say, you do it, block is no, you're it. Who on the rules committee of your planning is doing it? I think it should be the chair of the rules committee. And, she should probably tell the communications committee to put it on the paper. That's the way it is.
Okay, Rob, you want to be recognized? Well, this is as far as we go. Dick?
Pretty much never wrote it. The way I understand, this is supposed to work anyway, because any recommended changes would go to the rules committee. It would determine whether or not and what is required to make the change. Report that to the EC. The EC would decide whether or not you need to publish it. They would say that, and then the secretary is official correspondent with the outside world under the direction of the chair. Why do we have to say anything in our ruling documents on who has to make, who has to post it?
And I can confirm that's exactly what happened. Any more discussion on the amendment to amend? Oh, call the question. Let's call the question. Second?
Can we state what we're now, you're going to state
Pointing like
what
I
we're
have-
voting on?
Hold on, please. What?
You're going to state what motion we're
I'll
voting
state
on
it.
so everyone is
For the
clear.
record, we're being recorded. I'll definitely state it. Call the question. Was there a second on that? No. Pete, you're right. Well, I recognized Pete before I heard your second. Pete, do you want to speak?
I just want to say, if you don't have something in there saying who's going to do it, you're going to get a lot of people who are going to try and make amendments, try and get involved, and it's not going to nowhere. That's what's going to happen.
Okay.
A simple point of contact on any point where action has to be done is basically.
Okay. Do you want to call the question now?
Call the question.
Is there a second? All in favor of ending the debate on the motion to amend the amendment, say aye.
Aye.
All opposed?
No.
You said no.
Is this,
Okay.
this is the motion to amend the amendment
amendment.
to make it the rules committee's
Correct.
responsibility.
That's right. So now we're going to vote on that. All in favor of making it the Rules Committee, say aye.
Aye.
All opposed?
Nay.
That motion fails. We're back to the amendment to by the secretary. Any discussion on that? I will be happy to repeat that. We are now voting on the amendment to add, no, not the original. The amendment to add the words by the secretary. So the new text would read partially. Amendments must be published by the secretary of the official LPF, on the official LPF website. So it's those three words by the secretary being added. That is the current amendment.
I'd like to move to amend the amendment.
Okay. What's your change?
I'd like to add by the secretary or the chair of the communications committee. Since
Is there
they
a second?
are-
I'd like to amend myself. By the secretary or
Or the chairman of the communications committee.
Or the chairman of the communication committee.
And
there
I'm
was a
saying that
second.
because the communications committee does have access to all of our publications. They're the ones that usually we would send stuff to get published. In that case, it was not a secretary, or there wasn't a chair of the rules committee, or we had vacancies, it leaves the communications chair
Okay.
That's
able to do
another
that.
issue,
Yeah.
if you have a vacancy.
Okay. Any discussion on the amendment to amend? Sir.
I think Richard made a good point. These bureaucratic
This is the Constitution, yeah.
So I think you should consider, I'm in favor of just accepting the original amendment.
Okay. Omar, you recognized? That's correct. Any other discussion? All right, we'll bring this to a vote. All in favor of adding the words, what were they again?
By the secretary or by the chairman of the communications committee.
Say aye. All opposed? Nay. Motion fails. Back to the original motion, which is to by the secretary. It's the only part we're changing here. I recognize you. Okay. Okay, that amendment, if you're making an official amendment motion, that would be out of order at this point. But I understand your discussion. Any other discussion on to add the words by the secretary? That's all we're discussing, those 3 words. Could never happen. Okay, we'll bring this to a vote. All in favor of adding the words by the secretary, say aye. Aye. All opposed?
Nay.
Motion fails. Back to the main motion, which is the one that's printed as is in your package. And now it would make more sense for you. Carl, was that you? Did you want to speak again, sir? Go ahead. Okay. Might it be simpler?
That's not the only reason.
Well, yeah. Might it be simpler to just simply not adopt this and then just simply comply with the law? I'm just going to go with that.
What a novel idea.
Does anybody else want to, were you making a formal motion to amend, or were you just discussing? Is there a second to amend, as he said, to strike the entire text and to say what? We're in compliance? That's a
Here, let me-
declaration.
Here, this, I think what he, let me.
That's a declaration,
Maybe this
sir.
is what you mean. It could read, amendments must be published on the official LPF webpage, and notice of that publication must be given to the executive committee, the county affiliates, and all members of good standing according to the law.
Oh, okay, I see what you're saying. So we're going to strike,
After standing, add according to the law, and strike the rest.
Florida law.
Florida law.
Yeah.
Statutes, according to Florida statutes, amendments shall be stricken.
We have my law, Florida's law.
is there a second to that? Is there a second to that?
I second it.
Oh, man, that makes me grumpy.
Can't I?
Yeah, sure. Okay, it's seconded. So let's read, Dana, the secretary probably needs this. So we're going to read this amendment again. It's amendments must be published on the official LPF webpage, and notice of that publication must be given to the executive committee, the county affiliates, and all members in good standing,
In accordance to Florida statutes.
period. All of the text is stricken in that original motion.
Well, that's already, that's implied. All of our constitutional things have to be passed by 2/3.
Yes.
Ah.
Be redundant.
This is a constitutional amendment. I would double check that before I took that as gospel.
No, take it as gospel.
Dana has spoken.
The Constitution has to be passed by 2/3, bylaws a majority.
Oh, you're saying just, so that statement still stands? Okay.
already
No, I misunderstood.
implied.
Yes, that part of the statement, she ended that sentence, not the whole amendment.
No, I struck the rest of the words after, in accordance by Florida statutes, then all the rest of that would be stricken because the 2/3 thing is implied, because that's how all constitutional amendments have to be changed.
Where does it say that?
It says that in our Constitution.
Right, which we're amending right
Not
now.
on this,
I disagree.
Oh, is it on that, is that the one?
Right, this is
Okay.
where it says that.
Oh, all right.
So-
Well,
And that's not what you meant.
that would make sense.
Okay. So we're going to get this wording, give us just a minute, we're going to get this wording down exactly right.
So then it would just start up with constitutional amendments. It would be stricken until, then it goes, then it would say constitutional amendments
By a vote of two-thirds of the majority.
is amended by 2/3 vote of the
Okay,
membership. and
so
any
you're just
other-
striking the rest of that sentence, but you're leaving this constitution is amended by.
Yes.
Okay. That addresses that concern, I believe. So it was misspoken. I will
I
read
mean,
it.
that's his motion, so if he, that's what he means.
Is that, yeah, that's true. We're putting words in your mouth. Is that what you meant, sir? Okay. And then you seconded that. Okay.
I have an objection if we're,
You have a point of order objection?
no, are we just making the motion and seconding at this point? Because
He made an amendment and I seconded
I
it.
have an objection to that.
What's your objection?
My objection to the motion is, one, philosophical, in that we're no longer, by this motion, making notice on the behalf of our members. We're making it in order to satisfy the law. I'd rather that we comply with the law and say that we're doing it for the members. And if they take it out of Florida statutes, any requirement, now our members don't have the benefit of the 30 days. There's no longer the guideline of how soon our members should be notified. So I would object to striking it and just putting it in compliance with the law.
Okay. Lynn House, and you're next, sir, in the blue. Yeah. Yes. Okay. I'm going to respond to that. Well, may I respond to that, though, before you make that, try and make that amendment? This doesn't say only the LPF website. No, it can't. No, it can't. You can't put words in there. It's not the Supreme Court where you can just add law. Yes, this could be considered the minimum. That's correct. So you want us to mail it to people? Phone calls? All right, well, are you making that motion to amend? Then what is the wording? Order, please, order. What is the wording of your motion? Must be published and any other means? That's not logically feasible. And that's a good point. So we should bring that, but, I mean, and any other means, smoke signals? I mean, I'm intentionally being broad. I understand, you're trying to be inclusive. I know, but you just said something that includes a lot, and any other means.
At minimum might work.
Well, okay. Okay. John Thompson, you're recognized. You're next, Dana, because I want you to say that. Oh, he said it.
And notice. Correct. It's already there.
Okay, gentlemen.
It's
Okay,
there.
we're getting out of order there. And part of that's my fault because I should have finished his amendment, and I didn't do that. I apologize. So the wording of your amendment is after the word webpage, you want it to say and webpage and other means at the discretion of the EC chair. Is there a second to that? Is there a second to that? I hear no second. Sir? I hope not.
No.
Negative.
Yeah, that's,
Negative, we have it. You
No.
received, it was
Yeah.
published on the website.
yeah, we're not. See, this is what came up last year. This, yeah, so you asked a question. So, well, this is, we had last year, I don't recall if you were there, in Pasco, where we had the dueling attorneys discuss what it means to be noticed. And that's where it came up that notice could be published in the Riverside View paper and thrown out on the street where not a single libertarian might ever see it, and that would legally satisfy the requirement of notice. And that's where we're at. So to answer your question directly, no, we're not breaking the law as the law states because notice has been given. And this actually makes it stronger than what Florida statute says, except we just struck the 30 days.
Yeah.
That the word again, notify. Let's. This is where we went last year in great detail. Notification means we've published it, whether you went to the trouble to read it or not. And I'm just reiterating what was said. Whether you went to the trouble to read it or not is actually the onus upon you. We made it available. If you didn't go get it, that's on you, which was sort of what was taken. Yeah.
Of course, yeah. Yes.
Yeah. Yeah. Yeah, we can.
Yeah. These are just proposed.
Of course, we're the
these are just
delegates.
proposed
We can do it.
changes.
You know, those are proposed changes.
Hang on just a moment. Wayne was up before you, and then you're next, sir. Wayne, go ahead. Second. Okay. All in favor?
Aye.
All opposed? Okay. Where does that leave us?
Amendment to add for discussion by the chairman. I know, this is the one at the end.
All right, order. Cinder in. Cinder in. Cinder in. That's all right. Cinder in. Okay, everybody, order, 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 order. We've moved the previous question, which leaves us with amendment must be published by the secretary on the official LPF webpage and at the discretion of the EC chair. Correct?
By the secretary failed.
Oh, that did fail.
Strike
You're
by
right.
the secretary.
Darn it, I forgot to strike that. Yep.
EC chair.
So amendments must be published on the official LPF webpage and at the discretion of the EC chair.
Notice of that publication must be given to the executive committee, the county affiliates, and all members of good standing by the EC, at the discretion of the EC chairman, or at the LPF chairman. Was that
No.
something about the discretion of the chairman?
Yeah, that came after webpage.
Okay.
No.
No.
No. We're on that motion to amend, that nasty motion to amend.
To restate his motion?
Well, he stated it twice for us. Yeah,
We may need it 3 times.
okay. I'm trying to, and it's webpage and at the discretion of the chair, which is the part I don't get. Where'd he go? Ah, we're done then.
Okay. I like
Okay, I'm sorry then, I guess I messed that up. Okay, sir.
After 12 o'clock, I call to order the game. The agenda says we move on.
Call for the day, seconded. Second nominee, okay. We will, yeah, we'll have to put that down.
I mean, you can take a motion if you want to just skip through this
We
right
we
now.
have a
and then-
withdrawal.
You withdraw the motion? Okay.
No, we don't withdraw the motion, but.
He just did.
You just did.
Oh, he was doing the motion, okay. I thought you said.
Okay.
You were gonna withdraw the motion.
I'm seeking a motion to table this. We can pick this up later at
Or
the second
just-
time.
No, we just postpone with
Postponement. Seek a motion to postpone until
we return from adjournment.
when? We have to say when.
I don't have the agenda, so I mean, I don't know the timetable. I don't know what,
Until we reconvene.
yeah.
Okay. Is there a second? Okay. All in favor? All opposed? Ayes have it.
So just to clarify, when we come back to this, we will be starting on Constitutional Amendment 5, and there has been no amendments made to it so far.
All right. Still reads as.
It still reads as original.
All right. Here we are. Where's that item? 12:05.
But there is an
12
amendment
o'clock.
that had passed.
Second call for nominations from the floor.
Or no.
Thank you, Dana. I'll go ahead and
Okay.
get these nominations. Tell them to wait a few minutes. I'll be there. All right. This is the second call for nominations from the floor. Do we have any nominations for secretary at this time? Okay, hearing none. Do we have any nominations for treasurer at this time? For those following along at home, the at-large one is actually inappropriate, so that has been struck. Do we have any nominations for at-large 2 director at this time? Okay, those are the nominations. Sir? We will, but we can't do it there. This is just for nominations. Oh, did you want to put somebody else's name forward?
Advisory nomination? Yeah, we can still. We can take,
When we did it,
yeah, we can take additional for the
no,
advisory.
I'll just do it from the floor. That's why I'll do the advisory vote. Is that okay with you? Do it with the advisory vote from the floor? I'll take it. Don't worry about that. We currently have 1 candidate, by the way. Okay, where am I now? I'm at 12:05. Introduction of candidates for EC position, 2 minutes each. Suzanne Gilmore, would you like to address the committee for 2 minutes and make your
Sure.
case?
I had something written out, of course, it's in my thing here, it'll be a while, so I'll just try to wing it. I've been the secretary for 2 months. I was appointed following a vacancy, and I have been a secretary to a quasi-judicial board I was that for 14 years, and we had to have everything perfect in order to, we were subject to appellate court reversals if we didn't get it right. So I've had a lot of familiarity, certainly with doing minutes and getting things done properly and correctly. The quasi-judicial board, by the way, that sounds like almost like a status sort of thing, but this particular board was one that took the place of the judge, took the place of the court. And what we did was hear cases where people had difficulty with government, and they were ordered to do things that they felt were unfair. And we provided an avenue for these people to come before us and to be heard. So it was a wonderful board to allow people to have a voice in their government and in their own personal affairs. So I'm very proud to have been a member of that board. I won't go into all the other tons of things I've done over the years, but I've had many types of similar situations. I was also a founding member of my affiliate, and I was the secretary and treasurer of my affiliate at one time. and I've learned a great many things being here. I've had to pick up an amazing amount of things in 2 months, but we're getting there, and I appreciate the patience of those of you who see my personal growing pains, but I guarantee it'll be better next year. Thank you.
James Morris.
My name is James Morris, and I support Suzanne Gilmore for secretary.
Okay. Was that your speech to be treasurer?
That's my speech
That's
to be
speech to
treasurer.
be treasured.
Excellent. Well done. Well, I support James. Okay. That was the shortest speech for secretary, I think, or treasurer I've ever heard.
Treasurer.
Okay. At large 2, we have 2 people. Well, in the order that they were received, so that's how I'm going to do it. Mr. Russ Wood, would you, if you want, you can come up here and use the microphone, no problem.
Yes, please.
Thank you, Mr. Chair. As you know, I'm a candidate for Director at Large, too. Currently, I'm serving on the Executive Committee as a Region 4 representative, and this was a position that I was appointed to in November of 2015 because we did have a vacancy. When I did it, it was just to fill that position. But I've gained valuable experience on the Executive Committee, and because of this, I think this would be valuable experiences for a Director at Large. Currently, I'm the state's Events Committee Chairman, and as Charlez mentioned earlier, we've got a lot of exciting things planned for the Events Committee, and while I'm speaking, if we're going to need a regional rep from every region, so contact me, the chair, or your regional rep to get involved with that. I'm lived in Florida all my life. I'm currently retired. I worked in the power transmission and industrial supply industry, primarily in sales and management. I feel like that we've got to sell the Libertarian Party to potential new members. It's a sales job, and I have extensive experience in sales. Because I am retired, I don't have any conflict with a job to interfere with my duties for the Libertarian Party of Florida. So I'll be going to be a full-time Director at Large. My previous experience on the Executive Committee, I think, will be invaluable because it does take a few months really to sort of figure out what's going on the Executive Committee and how things work. And that's already behind me. I've already been involved in helping new affiliates with my Region 4 position. We've got, looks like real close to an affiliate being formed in Alachua County, so I'm excited about that. Actually, I was hoping we'd have the signed paperwork before this meeting, but it's still being worked on. I've worked with getting Highlands County formed, and we do have a brand new affiliate in Highlands County. Darlene Underwood's right here to represent them for the first time.
First time.
Yeah, Darlene.
I feel like that the most important things that we need to do this next coming year is membership, fundraising. Fundraising, and to say that again, fundraising is so important because we've got more and more things that people want to do. All the committees have got great ideas, but it's going to take money to do it. So fundraising is important. That's something I'd like to work with. I'd like to continue working with forming new affiliates. And the other thing is unity. We need more affiliates, more regions working together. We need more committees working together. It seems like so often that we do our own things, but we don't interact that much. So that's one thing I would strive to do, is to get affiliates and regions working together more as unity, all toward one cause. And that's going to be fundraising, membership, and persuading them to find candidates to run for office. So I hope you'll consider me for Director at Large, too. Thank you.
Joseph Quinn.
I took the wrong one. But you know what you're going to be doing anyway.
Oh, I have no clue. Mr. Joseph Witt, would you like to come on up?
All right, I'm just gonna keep it short and sweet because I like it short and sweet. I'm currently convention chair, and as you can tell, I've done a lot. I'm a hard worker, and I would like the opportunity to serve on the executive committee, and I think I'll make you all proud. Thank you.
Very good. 19 seconds. You didn't beat mine.
That was short and sweet. Okay. That was introductions for at-large 2. What is the time? The oppressive clock.
As written. You can-
Okay.
Oh, that's been moved.
Yeah.
Items pulled from the consent agenda, which was the one we were discussing, I believe. Our favorite. Motion 2016, ABM Con-5. Amendments must be published
Oh, yes, we were just.
on the official LPF webpage, and notice of that publication must be given to the executive committee, the county affiliates, and all members in good standing. We struck the rest of it from there, right? And then when this constitution is amended by? Is that correct, Dana? That's how I recall it. Yeah. We're back to our favorite one. Actually, there were no changes at all.
As written.
It's as written,
Yes,
yeah. There were no changes at
original.
all. Sir? Yes. You're right, I did say that. I am out of order, you're correct. That leaves us, well, these other ones didn't make it to the consent agenda.
So we need to get it done.
The Rules Committee.
Is there any
chair-
reason not to move forward with these other items? Don't hear any. Dana, do you want to do that? Okay.
Did the chair mean to say when we discuss the items again as opposed to reconvene?
Well, I did say when we reconvene. That's what I said. That's what's on,
Okay,
we
all right.
voted on, so. Language means what it means.
All
Yeah.
right.
I should have been more precise, but I wasn't. All right. So you're going to make that motion?
Well, we're still on.
Well,
We're going to bring this
because
back after the break.
technically, well, I said when we
Okay.
reconvene, and he brought it up, so I said we'll have to wait.
All right, so we will move on then to the bylaws. Bylaws just need a majority vote to pass. Bylaw 1 is pretty simple. It's a motion to amend bylaws Article 1. Move to amend bylaws Article 1 to retitle as county affiliates. It was previously named objects and purposes, but it discussed everything that had to do with county affiliates. So it's kind of a housekeeping issue, and that's pretty much the end of that.
Okay, you've made that motion. Is there a second? Any discussion on this item? Okay. The motion is, move to amend bylaws Article 1 to retitle as county affiliates. Article 1 currently reads objects and purposes. However, if you read what's in Article 1, there's nothing there about objects and purposes. It's all about county affiliates. So all we're doing is straightening out the title to say county affiliates. Any discussion on that? All in favor?
Aye.
All opposed? Oh, score.
Yay, victory. So, paperwork.
You're recognized.
What time is it right now?
That one's done.
Yeah, that was my favorite one.
Okay. This is a long one. This is the bylaws amendment, or bylaws, the motion to amend, a motion to amend the bylaws. It is the motion to amend bylaws Article 3, Section 2B. Move to amend bylaws Article 2, Section B by striking the entirety of the text and replacing with the following: by adding new Section C and D and renumbering, and by adding a new Section G as follows. Article 3, Executive Committee. Section 1, the officers and directors at large of the Executive Committee shall be elected at the annual business meeting by the delegate assembly majority
I don't have
vote
the
for a
package.
period of 2 years.
I don't have these motions.
Okay, James will get that. Go ahead.
Section 2, Executive Committee. Election of the executive committee officers, the chair, vice chair, and odd-numbered directors at large shall be elected in odd-numbered years. The secretary, treasurer, and even-numbered directors at large shall be elected in even-numbered years and in 2001. Regional representatives shall be elected at the annual business meeting and shall serve for a period of 1 year. These executive committee members shall take office upon the close of the annual business meeting and serve thereafter until the final adjournment of the annual business meeting at which their terms expire. Part A, no offices shall be combined. That is the language already in there. Now we're getting to the part where we would strike B and change it to, the executive committee shall fill vacancies of regional representatives, committee chairs, and committee members by appointment of the LPF chair with confirmation of the appointment as indicated by a majority of the votes cast by the executive committee. Part C, all nominations to fill vacancies shall be submitted to the LPF chair.
That's one.
Part D, the executive committee shall fill vacancies of elected positions of the LPF chair, LPF vice chair, LPF secretary, LPF treasurer, and directors at large as indicated by a majority of the votes cast by the executive committee via roll call vote. Part 1, each nominee for a vacated position listed in this section shall be offered the floor for introductions for no less than 2 minutes. Part 2, any candidate may choose to yield half of the maximum allotted time to another candidate. Part 3, by proxy, introductions of candidates shall be limited to 1 minute. Part E, the LPF Executive Committee should be notified by a resigning member of the Executive Committee within 7 days of the resignation. If the member does not submit a resignation, their unexcused absence from 3 monthly Executive Committee meetings or 6 bi-weekly Executive Committee meetings shall be considered a resignation effective immediately. Any member elected or appointed, this is part F, any member elected or appointed to serve on the Executive Committee or other LPF committee shall be a member of the Libertarian Party of Florida and shall, upon request, show proof of registration as a Libertarian voter in the state of Florida. Part G, which would be the other new part we were adding. The chair may appoint temporary officers and at-large directors to meet state-determined time limits for notifying them of the changes of the Executive Committee members. These temporary filled positions shall be confirmed at the next Executive Committee meeting. At the request of 2 members of the Executive Committee, a properly noticed meeting shall be called to elect qualified members to replace the temporary appointments for the entire remaining term.
Okay.
Is there a second? Okay. Dana, do you want to address this?
Yes. This came about because of what had occurred this year when we had the chair and vice chair both resign their positions subsequently, leaving the secretary to fill the temporary position of chair. At that point, no one knew what to do because it seemed that had not happened before. Some people had thrown their hats in to take the position of vice chair, a couple different people. I don't know if anyone else was willing to do the chair position, but what had happened was instead of having an election at the EC, the temporary chair appointed a chair and a vice chair. And there was people that wanted to be vice chair that weren't allowed to be heard by the executive committee and didn't get to pretty much run for the position as they would be run here because the delegates vote those people in, shouldn't just be appointed by the chair or by even the EC, but at the very least, the executive committee can vote on it, have an election type thing. So that's why we tackled this and tried to change it around. This is what we spent a great amount of time on in the Rules Committee because we separated it each by paragraph, and this is what we've come up with. So, about that, I will open the floor.
Well,
So as well
I'm actually chairing the committee. I know you have the big mic there. But, and I'm going to be a little bit, I'm going to speak to it a little bit in just that it would have been nice to have that guidance. That's all I'll say. Sir, you're recognized? You can. I'm going to need precise wording. No, what's the exact amendment you're proposing? You said something like. You're going to add to the end of B, okay?
Well, if there's
Okay.
no, oh, sorry.
If there is no chair, then as exactly what happened is there is a designated line of succession in Robert's Rules of Order, which is what we followed, and the acting chair is effectively chair at that point and has to follow these rules. Yeah, who's running the executive committee at that point? So that, which is exactly what happened.
There was no executive committee.
There,
It was gone.
well, no, the committee's still there.
Yeah, but
Yeah.
I mean, does that address your concern?
If the chair was gone and there was still a vice chair, the vice chair would
Right.
then conduct this. But since there was not a chair nor a vice chair, the next person in line was the secretary,
Right.
who was temporary chair.
Right.
So that person would be
You
tasked
become
with holding
acting
the
chair.
election.
So it's, you can address it in the bylaws if you want, or you can just let Robert's rules address it. You withdraw? And then you, and then you.
Kevin O'Neill, Hillsborough County. I'd like to amend section G, top line, right after the word directors, comma, I'd like to add, with their agreement, comma.
gee,
The chair may appoint temporary officers and at-large directors, comma, with their agreement. Is there a second? Is there a second on that?
that's exactly.
Oh, it'd have moved along faster if you hadn't seconded it. Is there any discussion on this? Hearing none. All in favor of adding, comma, with their agreement, comma, to point G, say aye. All opposed?
Yay.
Motion fails. I recognize somebody over there. Who was it? I'm sorry.
I like the way it's written.
My name is Bob Frank from Palm Beach. I'm addressing D1. I think the word should be no more than 2 minutes, not no less than 2 minutes.
Oh,
Agree.
So you're motioning to,
got me there. Good point.
all right, so, hold on, just so I understand. You want a motion to change the word, to amend, to change the word less to more?
And
Is there a
that was-
second?
Second.
Pick anyone out
I'm
there.
not sure we need discussion on this. Anybody want to discuss this?
Who made the motion?
All in favor?
Again? Aye.
All opposed? Motion carries.
Okay, who made the motion?
Who made the
Who
motion
made the
there
motion?
again? Mr. Was it
Sir, I need,
Stone?
your name, sir?
What was his name? Frank.
Thank you,
Thank
Madam
you.
Secretary.
And it was seconded by Tony.
Everybody.
Tony, pick Tony. did it.
Tony Sellers.
Sir, you're recognized.
It's easy, she knows the name.
All right, you motion to strike in the first part. No, you can't. That's out of order because that's not being changed by the motion. The motion is the underlined or the struck stuff. You would actually have to add a new motion to change that. Got it.
But that's, I will take that, the Rules Committee will change that.
But we'll
next
take
time.
that under advisement.
Yes.
Which was the second part? Yes, we can do that. We don't need to do the motion and everything. We're actually already authorized to make that punctuation change.
Yes,
So we're going to make that period. That's a done deal.
yes, that's. We've talked about that before.
Yeah, we've talked about that at great length. Omar, you're recognized.
I can't remember the long time call, ever, my process. So I moved to strike, part 3 in section B, where it says my process is not the candidate coming to finish when I would strike that in
Is there a second? Okay. Omar moves to strike Section 2D, Part 3, which reads, by proxy, introductions of candidates shall be limited to 1 minute. Okay. Is there any
I'd like
discussion
to-
on that?
I'd like to be recognized.
You're recognized, Dana.
The reason that we added that, 'cause this isn't, we usually don't do by proxy voting. This isn't to allow by proxy voting. But last year, I think it was actually Mr. Invictus who wanted to be introduced, but he wasn't there. So Bill Wolsifer had wanted to give an introduction on his behalf, I believe, or someone like that. And, and that there wasn't any precedent set for that, so usually we don't do by proxy anything. So I originally had said no, but then Bill had brought it up, and then we allowed him to do it. So that's why we added it in here. So from now on, this would just be a by proxy introduction of a candidate, so that if the candidate wasn't there, or if any situation like that happened, they would be allowed to introduce that candidate. They would only, by proxy for up to 1 minute.
Yeah. The word proxy may be a little bit concerning, but it's like an agent for you. They're your announcement person. Is anybody else, Omar, you've spoken, anybody else? Omar, or go ahead, Mr. Kinwilly.
Ken Willing, County. I agree that we should leave that. If something comes up and a member isn't able to make that call and introduce themselves, then they should be allowed to have someone make a short introduction and say who that person is.
I agree. Omar, did you want to talk to that again? Because you were standing. And then you back there, way at the back. What is, okay.
And then you just don't vote for them.
Yeah. Mr. Augustus?
Oh, that's what it was.
Any other discussion on this? All right. We'll go to the question of whether to strike this. All in favor of striking part 3, say aye. Aye. All opposed? Nay. Motion fails. We're back to the main motion. Any more discussion on the main motion? I think we'll call it. Okay. All in favor of this motion to do all these things? What's it called? ABM by 2. Say aye. Aye. All opposed?
Don't get excited.
That's only because we discussed it for like 45 hours.
Dana, would you like to be recognized for number 3? Do
What about being recognized?
you want to?
Yeah.
Okay.
This is for bylaw change number 3. Motion to add bylaws Article 3, Section 4G, which would state special meetings. Special meetings of the executive committee may be called by the chair or 2/3 of the EC at any time, provided the purpose of the call, time, date, and contact information is given 24 hours in advance. Only items listed in the call for a special meeting shall be acted upon at the special meeting.
Is there a second? All right. Dana, did you want to put a privilege on this?
This was just, we didn't have anything in there regarding having a special meeting, and I know they were being called, and there wasn't anything that directed or gave anyone direction on how that was supposed to be done.
Robert's rules were actually, they spoke to this. There was nothing. You couldn't do it. Sir.
I guess according to the information, I believe it's considered a special meeting with the EC during the convention when you confirm the appointments of the delegate. And by specifying call, you may have to call.
Yeah.
I see what you're saying. Purpose of the call. So would you motion to strike that purpose of the meeting?
Yes. In all instances, calls to become.
Okay, so you're motioning to replace the word call with the word meeting in all instances on that. Is there a second?
Second.
Okay, any discussion on that item? All in favor of replacing that word?
Aye.
All opposed? Okay. Any other discussion on the main motion?
Call the question.
As amended.
Wayne?
My concern is 24 hours. Okay, you know, if somebody's trying to run something
Yeah.
Okay, and certain people get the notice, and other people don't get the notice, you know, you get the effect of stacking the deck. Okay?
Right.
Just, did you address that?
Dana, did we address the
Yes.
24 hours?
I mean, there was some times, I know when I was chair, that we had issues come up that needed to be addressed, and I would notify everybody on the EC. Sometimes we would do an email vote or have an email discussion, but there still has to be a quorum, and there still has to be, you know, we still have to make sure everybody has checked in and seen it, and we usually would give 24 hours. Sometimes we've gotten it finished in 3 hours if everybody's on there and checks in and we have the quorum, a proper quorum. So, and then people could have come in after the fact and said what their vote was if they didn't get in time, but it's never changed the outcome.
Sir?
It possibly could.
Okay, sir?
Quick information, so, this is going to be limiting the article special meetings, it's not going to be any standard.
Right now, there is nothing,
It expands it completely. Right now, there is no
yes.
ability to call a
This
special meeting.
expands it. Before, when we were doing it, we were actually doing it, and there was nothing, I mean, there wasn't anything that said we couldn't, but there wasn't anything saying
Yeah,
we could.
this authorizes it.
This actually now authorizes that we can do it, and,
It's actually implied that you can't because of the notice
Right.
rules.
right.
Okay, sir?
Just a question, do we need to define meeting? You know, can it be a conference call, can it be a?
Do we need to define meeting? No, well, you asked me the question. I would say it's no, it's well understood, the
Yeah,
word.
it's defined in the governing documents and elsewhere.
Well, no, because it could go either way. We could do it on phone, we could do it face to face. We could do it.
We wouldn't
or-
get a
Sir?
quorum.
Never get a quorum face to face.
You motion to insert the words "at least" in front of 24 hours. Is there a second?
Okay.
Any discussion on that? All in favor of inserting those words "at least," say aye.
Aye.
All opposed? All right. Back to the main motion.
At least.
Picture of everybody.
That's good. You could get 72 hours notice. That's good.
Yeah.
Yeah. All right, any other discussion? I will read the motion. Special meetings of the executive committee may be called by the chair or 2/3 of the EC at any time, provided the purpose of the meeting, time, date, and contact information is given at least 24 hours in advance. Only items listed in the meeting we replaced that word call twice, for a special meeting shall be acted upon at the special meeting.
I would like to make a motion that we strike that second word meeting and put in, replace it again with that word call.
Yes.
Well, if you undo that, you're going to have the exact problem of what about a face-to-face meeting? That's why it says meeting, listed in the meeting. It should probably say listed in the notice. You want to make that motion? Is there a second? Second. Any discussion? All in favor? Aye. All opposed? Oh,
Who made that motion?
Jennifer Gilmore.
Thank you.
Who was the second?
Who wants to go on
We've
record?
lost seconds
Tony,
already.
Tony.
I think that
Default,
the
Tony's
delegate
default.
second, the delegation. Any other discussion on the main motion? I'll read it again. That's one of my favorite things. Special meetings of the executive committee may be called by the chair or 2/3 of the EC at any time, provided the purpose for the meeting, time, date, and contact information is given at least 24 hours in advance. Only items listed in the notice for a special meeting shall be acted upon at the special meeting. Any discussion on that? All in favor, say aye.
Aye.
All opposed? That sounds like a majority. Motion passes.
Hey, it passed.
Yay.
One down.
Okay, we have
Still 38. What else have we got left on it?
Yeah, I think we could do this one. All right, we'll move on to bylaw change number 4. Move to amend bylaws Article 4, Section 3. Move to amend bylaws Article 4, Section 3 to add the word verifiably and to delete the words or have signed a new voter registration or party change form to become a valid registered LPF voter to the LPF secretary. So it would now read Section 3. Delegates shall be members as prescribed in Article 2 of the Constitution on the day of commencement of the annual business meeting, and a delegate must be verifiably registered Libertarian Party of Florida voter in the state of Florida, obviously, prior to the start of the annual business meeting. Delegate status may be denied by 2/3 majority vote of the executive committee if a potential delegate has been found to have violated the non-aggression principle.
Is there a second? Any discussion on this?
Ken Wiley, second.
Do you want me to explain what this does first?
Yeah, she has point of privilege and then you, sir.
Last year, we passed a motion saying that people could register to vote right before, that they could register here as a Libertarian and then be a delegate. Then we realized there was no way for us to know that they were even eligible to be a voter, or that they even lived in Florida, or they were a resident, or anything like that. So, but the SOE knows that information. So if somebody wanted to go to their SOE the week before the convention and change their registration and could come here with a copy from their SOE saying it's changed, or they could prove it any other way, go online or show you us their card, they could be given delegate status. But you cannot change your registration at the convention, because we have no way of verifying in that you are even a resident.
Which I believe has happened at this convention.
Yes.
Sir.
Joshua Colson, Region 3. Am I to understand that verifiably is intentionally vague?
Yes.
Yes.
That's my question.
Mr. Jensen. Please stand. Please stand. Motion to amend. You want to strike the words voter in the state of Florida? Before you do that, before anybody seconds it, first off, that's actually not part of the amendment, but that was added specifically in case somebody was a registered voter in Georgia or something like that, even though it does say Florida ahead of that. Do you
And
still
that's
want
one
to?
of those things we could change.
Yeah, do you still want to do that? Okay, is there a second? Actually, can we touch that? We can't.
No, we can't.
We can't. I'm sorry, I'm out of order.
But we don't have to
Well-
wait until the next convention to delete that in
Yeah.
the state of Florida, because it's just a.
Yeah.
It's just a.
We actually have the
grammatical.
authority to make it clear without changing its meaning. Any other discussion on the main motion? Okay, and Joseph Wendt. In that case, seeing none, all in favor?
Aye.
All opposed? See, bylaws are by majority. That sounded like a majority.
It's me. Do it again.
Well, I did. We'll do it by standing. I prefer by standing. Mr. Wendt and Mr. Omar, I need you to sit down. We're going
Sit
to
down.
vote by rising. All those who wish to make this amendment, please rise. And if you don't want to, please stay seated.
That looks like a majority.
Okay.
All right, please go ahead and be seated. All those who oppose this, please stand. Okay. You seated? That's fine.
1, 2, 3, 4,
okay.
5, 6, 7, 8, 9.
9.
We'll call them the Gang of Nine.
9
Okay.
opposed.
Motion passed.
The small local group, the Gang of Nine.
Okay, at this point, we will run up against a hard time deadline, so we are going to go ahead and move to, where is my agenda? It's right here.
Recess for lunch.
Do I have a motion to recess for lunch and reconvene at 3:15? That was Mr. Bowen. Is there a second? That was everybody. Pick someone.
Second was.
All in favor? All opposed?
Seller seconded it.
Get out of here. Have a good time.